today, November the 9th, 2018, at the San Diego County Water Authority, and John Carter has been kind enough to come in, and I should give John a shout out because we did do an oral history with John a little over 10 years ago, and we had a camera failure. Actually, it was operator failure, but we'll call it what it is. And there was no sound on the oral history. So John was kind enough, after being cajoled for 10 years, to come back in and redo all over again. So John, thank you very much for
welcome
being willing to sit through this again. And thank you for dressing. I think you're probably the second or third person out of all 40 of them that came in looking like a water professional.
Well, guess what? It was just fortuitous because I had a meeting earlier this morning and I needed to dress this way. So, so who knows what I had looked like otherwise.
Well, in any case, thanks for leaving your suit on. Let's start out with just a little introduction. When the first interview took place, you surprised me when you told me that you were actually from the Imperial Valley, and I'd known you for a long, long time, and I never knew that. So give us a little background there, and then relate that to what you have done for the past 40 years.
In 10 minutes or less?
Oh, no, we have time. Okay. We have all the time in the world. Well, we have all the time in the world. But no, take your time and talk about what you want to talk about.
All right, sounds good. Well, as you said, I was born in Imperial Valley, grew up there, went on to college and law school, and a little bit of background about kind of why I have been interested in water law is my paternal great-grandfather actually helped build the canals in Imperial Valley, many of which are still being used today, of course, with some remedial efforts and maintenance. Then his son stayed there and became a farmer. And interestingly, reportedly, he grew the very first iceberg lettuce crop in Imperial Valley. And they said that everybody was surprised about that.
What year approximately, or circa, would you be talking about?
Oh, that would have been in the late 20s, early 30s.
Wow.
And so his son, my father, decided that he wanted to go on to college, and he went to the University of Southern California, and unfortunately had to leave school early because he needed to come back and help his father in the farming ventures. And while he was at SC, he befriended somebody that had been an attorney, and my father, decided he wanted to become a lawyer. And unfortunately, that didn't happen, because by the time he came back, helped my grandfather didn't live too much longer after that. So my dad had to take over the farming operation. And so that's how I grew up, essentially on the farm, dealing with agriculture. And I remember that he was always telling me, as were his farmer colleagues, telling me how important water was to the viability of Imperial Valley. And so with that little background, I guess you would say my roots are literally in water. In the valley. So.
But you got out of it. I mean, you got out of the roots part anyway, mm-hmm. and moved into lawyering, if you will. And why did that happen? Was it an homage to your grandfather or your dad, or just something you wanted to do and saw a need for?
Well, I was always, and still am, very interested in in the Imperial Valley and what our predecessors had accomplished there. Water rights that they acquired, as you know, substantial water rights. And so after college, I decided to go into law school. And I, of course, being in contact with my dad and his friends in the farming business, again, just had a really good appreciation for how meaningful the water rights were to the people of the valley. And as you can imagine, without those rights, the valley probably wouldn't be existing today.
Well, tell us about those rights as they affect Imperial and its sister ag agencies, and then ultimately the urban agencies. Imperial has a very, very large allocation, if you will. How did that come about, and has it been difficult to protect it?
I'll tell you how it came about, but yes, it's been very difficult to protect it. That's essentially all I've done over the last 50 years. Having said that, the predecessors of the Imperial Irrigation District were individuals and a company that appropriated over 7 million acre feet of Colorado River water under California law by posting, if you will, posting with a hammer notices of appropriation at a diversion structure called Hanlon's Heading. And that really was the basis for the division of upper and lower basin water rights, Colorado River rights, under the compact of 1922. One could argue that without those appropriations made by Imperial Valley predecessors in interest, other states would have had larger rights. Perhaps the lower basin might have had less than 7.5 million acre feet a year, which was divided as part of that compact. And so with that background, once the compact was approved and then the Boulder Canyon Project Act was approved, it became necessary for the agencies within the lower basin to divide the approximately 7.5 million acre feet of Colorado River water annually. Again, California's share of that was 4.4 million acre feet out of the 7.5 million acre feet. Nevada had a small amount, 300,000 acre feet. Nevada, 2.8 million acre feet.
No, Arizona.
I said, yeah, Arizona, I'm sorry, correct. But the reason that California was able to obtain the rights that it did ultimately agree to was because of the original IID appropriations of 7 million acre feet. Because at that time, as you know, Palo Verde, of course, had some pre-existing rights. IID had rights. Small amount of water for the Yuma project had some rights. But at that point in time when we're in those negotiations, MWD didn't. They didn't have rights under California law. So California then ultimately agreed to divide up the 4.4 million acre feet that it acquired as part of the Boulder Canyon Project Act negotiations. And that came about in 1931, a document entitled Seven-Party Water Agreement, whereby the prior right holders, Palo Verde, Yuma Project, IID, and Coachella, shared the first 3.85 million acre feet annually, with IID and Coachella utilizing essentially 3.85 minus priorities 1 and 2, Palo Verde and the Yuma Project. And those were flexible rights vis-a-vis IID, Coachella, and the other ag agencies. And Coachella lands were to be served under the IID contract. And Coachella didn't want that. They wanted to have their own right. And so IID and Coachella entered into a 1934 agreement called the Compromise Agreement, whereby Coachella would have its own rights, but they would be junior to IID. So under that priority agreement, once priorities 1 and 2 rights were satisfied in any 1 year, essentially IID could use the balance of up to the 385, and Coachella would have 0.
Is that what you meant by flexible rights?
Yes.
Can you define that a little? Because we're going to move to the quantification settlement agreement, which plays into that.
Mm-hmm.
So what do you mean by flexible rights? Sounds scary.
Well, let's start from the top. Palo Verde Irrigation District has about 105,000 acres in its service area, and the water that it takes, it returns drainage water back to the Colorado River. So their rights were more or less governed, and still are, by the amount of water that can be reasonably used in that amount of acreage for irrigation purposes. IID, next in line, rights is what I said, is that after priorities 1 and 2 have been satisfied, IID could use everything above those 2 rights up to 3.85 million acre feet. And so it was flexible. And in fact, IID, the Imperial Valley has in the past used as much as 3.4 million acre feet of Colorado River water.
So if they wanted to put 4 acre feet of water on rice, they could do that.
Correct.
Up to the limit.
Correct.
Or if they wanted to put 1 acre foot of water on, I don't know, a pomegranate grove, then they could choose to do that,
Correct.
as long as they stayed with the acreage limitation. 'Cause I'm not sure that that's correct.
That's not correct.
Okay.
They could use the amount of water necessary to provide water for the farmers to irrigate their crops within the total irrigation district boundaries.
And they get to choose the crop.
And they get to choose the crop. So to that extent, it wasn't a cap. It was a maximum cap of 385 minus 1 and 2. And so that created a tension with respect to Coachella Valley Water District, because they didn't have quote, a secure supply, since IID arguably and legally could use all of the water that was left over after priorities 1 and 2. And that ultimately, we'll talk about later, is one of the important factors involving the quantification settlement agreement. Because that did provide Coachella Valley Water District with a fixed amount of the total of 3.85.
And did it do the same for other water agencies, or only Coachella got a fixed amount? The reason I ask that is because most people take the words quantification
Yes.
settlement agreement, and that means that everyone was quantified. Everyone got a hard number, and I'm not sure that's accurate.
That it isn't accurate because, excuse me, Palo Verde Irrigation District still has a flexible right. And as part of the QSA, we don't want to get into the weeds here,
Yeah.
but as part of the QSA negotiations, people said, well, wait a second, Palo Verde could start using more water. That would then impact the next users.
Okay, we're going to get to the QSA a little later because it's a difficult subject, and you're from my perspective, you're one of the people who understands it best. But before we get there, let's talk about you going back and practicing law in the Imperial Valley. I mean, you go to school, you go to law school, you get a law degree, you pass the bar, you know, you're a big time attorney, and you wind up in the Imperial Valley. Was that the dream?
I always wanted to go back to the Imperial Valley. And I always wanted to, hopefully become an attorney. And I wanted to do what I could, to help my clients and the community. And especially, I still focused upon water law. And that story is somewhat interesting.
Well, you said something interesting there. Hold that thought.
Okay.
Because I need to clarify. You were never staff at the Imperial Irrigation District, were you?
Correct.
You were always,
Contract attorney.
contract attorney.
Correct. Even though we had titles, just as if we were on staff.
Why did either you do that, or why did Imperial do that? Establish a contract relationship as opposed to an employment relationship?
I don't know the exact answer, but I suspect that IID at that time didn't think they needed to have in-house counsel. There wasn't a whole lot going on.
What year are we talking about, by the way, when you signed on with them?
I would have been in 1967.
Okay. Well, that was pretty quiet.
It was very quiet, and that's the interesting part of kind of the story of why I became more involved in water law.
Okay, well, let's go with that then.
So during my first year of law school, I visited with the then IID chief counsel, contract attorney, contract with the Horton Knox Carter and Foote then Rutherford law firm, and told him that I was interested if they had availability to come back the next summer and get an internship. And Reggie Knox said, well, you want to come back to the Valley and you want to practice law? Sure, we'll make that happen. And he said, by the way, what kind of law are you interested in? And I said, well, I'm really interested in practicing water rights law. And Reggie kind of chuckled, leaned back in his chair, and said, well, John, if you really want to practice water rights law, you should go someplace like the Central Valley in California, because we just don't practice much water law here. And I said to him, I said, I think that's about to change. And from that point on, Reggie, every time we met, always reminded me of that conversation. So, when I graduated from law school, I came back. But about 3 months after that meeting in 1964 with Reggie, the Department of Interior issued a ruling repudiating its 1933 position that the acreage limitation, 160 acre limitation, under the Reclamation Act, did not apply to the lands in Imperial Valley because they had had a prior vested right to water, the 7 million acre feet we talked about earlier. And so I worked some on the acreage limitation issues during law school, came back in 1967, joined the firm. The United States filed a lawsuit that year
Against
Imperial, saying the acreage limitation does apply to the lands within Imperial Valley, and therefore an owner can only own 160 acres and only get water for 160 acres. And so that was the start. And from that point forward, even though my prediction was correct that in 1964, I had no idea the immense journey that I was going to be on and the challenges that I and the Valley would face.
Well, how was, before we move on to additional challenges, how was that one resolved? Because that's not going to work.
You go to court.
Well, sure.
Yeah. So they filed a lawsuit. The United States did. A couple of doctors in the valley, and I kid you not, their names were Yellen and Holleran. And they yelled and hollered a lot. And so they tried to join the lawsuit and did somewhat successful, got into the litigation.
Were they gentlemen farmers?
No.
In addition to being doctors?
They were just doctors.
What was their position? I mean, I'm not sure I understand why they would join the lawsuit.
The story is there were perhaps two reasons. Remember, this is just when I just started practicing law. The story is, I don't know whether it's correct or not correct, that they represented all of the farm laborers in the Imperial Valley and provided medical treatment for them. They thought it would be a good idea that those farm laborers, to the extent that they could buy property, and that probably would have been easily to do if the acreage limitation applied, because once that decision came down in '64, land values plummeted. They went like from $1,500 an acre to $600 overnight. So they had that interest. And the other story that I had heard was that they were they were trying to get IID to enter into an agreement to allow those doctors to provide medical services to the IID employees. And IID said no. And so they were upset.
Wow. I mean, that's
That's
a strange web to weave.
I know. But they hired an attorney out of San Francisco, and they were, fairly successful. But we finally ended up in the district court in San Diego, 1971. Judge Turntine said the acreage limitation does not apply to the lands in Imperial Valley that had been utilizing Colorado River water at the time of the Boulder Canyon Project Act enactment. In other words, those lands had vested rights.
And that was virtually all of them.
Correct. There was a small amount left over that got cleared up later. So IID had to appeal. United States appealed along with the landowners, yelling and hollering, appealed, and that went to the Ninth Circuit Court of Appeal. And even though the Ninth Circuit said that yelling and hollering didn't have rights to participate, that the acreage limitation did apply to the lands. In other words, reversed the district court decision. So IID then had to appeal to the United States Supreme Court. And they took the case and ruled finally in 1980, that Turntine was right, that the lands did have vested water rights, primarily what they now were calling present perfected rights, and that the acreage limitation didn't apply. At that same time, just so you get a sense of what's going on, at that same time, Arizona v. California lawsuit was up before the Supreme Court. And as part of that decision, in 1979, the Supreme Court said that, first of all, in 63 and 64, the Supreme Court said California's rights, the division in the lower basin was correct under the Boulder Canyon Project Act. California gets 4-4, Arizona, you only get 2-8. Nevada, you get 300. At the same time, they needed to define under the compact what was meant by present perfected rights, which is a higher priority right. And in 1979, Supreme Court ruled that IID had present perfected rights of 2.6 million acre feet a year. So a lot was going on at that point in time.
Why? Do you need a refill on that?
No, I'm okay, thanks. Sorry about my cold, but
You're one of the few people I could ask this and maybe get a meaningful answer. There's a lot of lawsuits out there about everything. Yeah, people suing everybody. Why does water law, why do lawsuits over water take as long as they do? And if you look at Arizona v. California, it's the longest running Supreme Court case in the history of the Supreme Court, I understand. And maybe you can put that to rest. Is it settled? This case right here, before you came in, we were talking with Tom Levy, Coachella Valley Water District, and you're probably familiar with several of the cases that Coachella ran because Imperial was involved. But some of those took like 12 and 15 years. So without getting at each one, because we'll be here for a week,
right.
But what's your thought about why water in particular is such a difficult thing to litigate?
Oh, that's a good question. I don't think I've ever really articulated my thoughts about that, but I would say, first of all, without water, we don't have anything. And so that resource is extremely valuable, as we continue to find out. And people will almost fight to the death to protect any rights they think they're entitled to. And that's what we have courts for. There are a lot of other interests involved in that kind of litigation. So more people join the fray, and our court system, it just takes time to go through it. Now, this case could have been over, or the acreage limitation case could have been over if everybody said, okay, we'll accept Judge Turntine's decision. 1971. But they didn't. And the case would have been over later if the Ninth Circuit agreed that Turntine was correct. The case could have been over in the Ninth Circuit also if the United States Supreme Court decided it wasn't going to hear the case. Right. So you never know. But it's, as I said, I think people are very passionate about their rights to water, and that's been the way it is.
Is Arizona v. California over, or is there still more to do?
It's over, in my opinion. No, it's over, in my opinion, unless another issue arises. But the issues that were litigated, as far as I'm concerned, it's over.
Fair enough.
But let's talk about this just briefly. I don't want to get into this today. We don't have time. But we have shortages on the river. There's not enough water to meet all the needs. So if the United States comes down and makes a decision, well, we've decided that perhaps all of these rights that have been granted before need to be modified or reduced. For example, maybe IID's rights should be somehow reduced. There's going to be litigation over that. But that could happen.
And well may happen as Lake Mead and Lake Powell continue to
Right.
draw down. Okay, 67, you're kind of a rookie attorney, and the muck hits the fan, and so that one is on the road to resolution, I suppose. What's the next dark cloud in the sky? Not the little stuff, but what's the next?
Well, when it comes to water, there's nothing little about it.
Well, probably.
It just isn't that way. Let me just give you a side note. I'm currently representing Vista Irrigation District, and along with the city of Escondido, the 5 Indian tribes in northern San Diego County have been disputing the rights to the San Luis Rey River for 100 years.
Yeah.
As part of those packages of issues, in 1988, we got the All-American Canal Lining Act, saying, let's line the All-American Canal, we'll save some water. Oh, and besides, why don't we make 16,000 acre feet of that savings available to help settle this issue with the Indians in Vista and Escondido. And my point is that I've been defending in the past IID and Imperial Valley's rights, still do, Imperial Valley's rights, of 3.85 minus priorities 1 and 2, a cap of 3.1 for a term of years. But the Vista in Escondido and the Indians dispute is over 16,000 acre feet. So the perspective is, it doesn't make any difference. 16,000 acre feet is just as important as 3.85 million acre feet. And so people are just as passionate about those rights, no matter what they are.
Well, there's also a money perspective, wouldn't you think? And what I mean by that is that residential water within Vista Irrigation District sells for, I don't know, $1,200 an acre foot, $1,500 an acre foot to a homeowner. Something, something north of that.
Hmm.
And an Imperial Valley farmer is paying, I don't know, less than $30 an acre foot, would be my guess. And I guess the reason I bring that up is because on the one hand, you're talking about quantity of water, which is important, 16,000 versus 3.1 million. But on the other hand, you're talking about value of water. It's more valuable to VID, to Vista Irrigation District, per acre foot. It's significantly more valuable than it is to someone at Imperial, is it not? Or does that money difference, which is huge, not mean anything when things get unraveled in court?
Some would argue that an acre foot of water one place should be at the same value as an acre foot some other place.
But that's impossible.
Well, part of the problem is infrastructure, delivery costs, quality of water costs, environmental costs. And so that all comes into play. But my point is it more valuable to a municipal user? I don't know that I would agree with that, frankly.
Well, okay, that's fine. I'm just pointing out the disparity between
Yeah.
M&I water and agricultural,
I understand.
and it's huge.
I agree with you.
Okay, so here you are representing Imperial. There are some lawsuits over Imperial Irrigation District overwatering, using too much water, flooding land, things like that. That's a big one, I would think. Tell us about those. I guess I'm speaking specifically of Elmore, and then there was another one before Elmore, and I don't remember that was. But how does that play into Imperial's water right, and how does an IID farmer or a board member justify using more water than they really need to use? And I know I'm not being critical, there are justifications, but I want to hear that from you. Nobody gives a damn what I say. So you got water flowing into the Salton Sea and flooding land. And how does all that get resolved over a lot of time?
Well, there's primarily two ways to resolve it. One is to litigate, and another is to enter into collaborative arrangements that would be win-win for everyone. And so as the acreage limitation case was going on through the courts, Arizona v. California was going on in the late 70s. California Department of Water Resources said, we think the farmers in Imperial Valley and the IID itself can be more reasonable in their utilization of their huge Colorado River water right. That ultimately found its way to the State Water Resource Control Board fairly soon after. that. My recollection, that DWR report was maybe 78. So again, in the context of me working on the acreage limitation, Arizona v. California, so this comes along.
Mhm.
And I finally I sat down and made a list of factors that Imperial Valley ought to be considering, and IID ought to be considering. That there's been a history of droughts, populations increasing, Colorado River water, these are just a few. Colorado River water is not sufficient to meet all needs. Arizona and Nevada are going to be using their full entitlement. Met's not going to have that surplus water from Arizona and Nevada available to it, et cetera, et cetera. And I said to the ID board, I think you ought to seriously consider agreeing or inviting municipal users to come in and sit down and have a frank, candid discussion about entering into a collaborative arrangement whereby IID, the valley, could lease water for funds that can be used to make the district more efficient, even though my position is they were efficient compared to other areas. But I didn't think that that was going to go away, that IID in the valley was going to continue to have a target on its back. So I drafted a resolution at the board's request, 8-84, so it would have been in early 1984, essentially doing that, inviting others to come in and talk to us about entering into some kind of arrangement. That was about the same time that Carl Baranki became general manager at MWD. I think he started maybe in 83.
That sounds about
I
right.
think that's right.
Yeah. He was general counsel.
He was general counsel prior to that. And so we entered into some discussions. And I never forget Carl taking me, as only Carl can do, and grabbed me by the shoulder, young attorney, just literally getting his feet wet, not in water, but in the law. Taking me over we were in LA, to a little outdoor table and saying, I think you and I have the same vision about how we can make a difference. And I said, do you mean something similar to water marketing? He says, I'm not going to use that term, but yes, John. He says, if they would just leave the two of us alone, I know we could come up with an agreement that would be acceptable. Of course, I said, yeah, that's true, but that didn't happen. Of course, all the politicians needed to get involved in that.
Well,
That was the genesis then of the agreement that we entered into with Met in 1988, Water Conservation and Transfer Agreement.
and that became known as IID-1.
Right.
And I believe Chuck Shreve was the GM, right, at Imperial. Wasn't there an exchange of white hats and black hats at his dinner?
Yeah. Yeah.
Ring a bell?
Oh, yeah, that's true.
Yeah, I think Chuck was there.
Yeah, that's true.
Well, describe, if you would, then, the nuts of that agreement.
Well, that was essentially fairly simple agreement. It was payments by MWD to improve IID's infrastructure, primarily. Some pump back systems on farm, but the bulk of it at that point in time was canal lining, et cetera. And so that was, I spent quite a bit of time after that litigation was kind of settled, as we talked about, and we had litigation with the State Water Resource Control Board at that same time also, saying they didn't have the power, the authority to make a determination like that. Even if they did, IED was, the farmers were operating reasonably, but we lost that lawsuit, which is understandable why they took the position they took and why the courts took the position they took. But we ended up with an agreement with Met and decided to move forward with that, again under the guidelines of this resolution I'd prepared, 8-84. And went back to MWD just after Carl left, 93, 94, something like that, and said, we think it makes sense to do another deal. We have more water that we can conserve, but we need the funds to do it. And I was at a board meeting, I remember it vividly. This is going to be MWD 2. And
One of your board meetings or an MWD?
no, MWD board meeting. And Woody was there then.
John Woodruska.
John Woodruska. And the bottom line was they, as you know, had this Reliability Plus program and said, essentially, my words, not theirs, why should we pay you for water when you leave it in the river and we get it for free? So therefore, why follow through with Carl's vision, my words, not theirs, Carl's vision of working out a consensual arrangement with IID. So we said, okay. And San Diego, of course, was aware of that, since they have members sitting on the MWD board. And they came to us and said, how about us? Can we negotiate the water conservation and transfer agreement
With the Water Authority.
with San Diego County Water Authority?
Let me take you back a step though, because I want to talk about IID 1, because there was another water agency in the way, and we need to talk about Coachella Valley and what their issue was at the time and how it was resolved, because it was. But
yes,
from your perspective.
sure. Coachella said that IID didn't have the right under the priority system to transfer conserved water around Coachella to MWD, or anybody for that matter. And we said, we do, under California law, and it ultimately that issue got resolved through an agreement with IID, MWD, and Coachella.
Well, Coachella got pretty much what they wanted, didn't they? I don't remember the exact outcome of the negotiation or the agreement, for that matter. But I mean, you got MWD with all the money in the world on one side.
MWD and Coachella entered into some side deals that IID really wasn't part of.
Oh, okay. Well,
And it's called the agreement. Excuse me, the agreement was called the approval agreement. So Coachella says we approve. You can conserve water through these methods and transfer it to MWD.
So in effect, IID stood aside and said, let us know when you have that worked out.
Yeah, correct.
Okay. Did Coachella get in the way of the San Diego deal as well?
Of course. Why do you ask?
Because that's my job.
So MWD and Coachella got in the way
Yeah, well, that's true. That's true.
and said the same thing that Coachella had said before. IID doesn't have the right to transfer conserved water to San Diego County Water Authority.
And so how does that get resolved? I mean, don't say through negotiation. I mean, we need some detail. There's
Well, through a lot of negotiation.
a lot of negotiation.
So they filed some litigation, I think, also.
The water, water authority? Or?
MWD and Coachella.
Oh, okay.
Yeah. Okay. Let's back up just a little bit.
Okay.
About this same time period, in 1992, the Department of Interior says, we think we have the right to limit IID's water rights. And we think we're going to reduce you by, pick a number, 300,000 acre feet a year. That they weren't successful. We beat them back on that only because we said, we've sued you before, we'll sue you again, we'll win. We ought to sit down and work something out.
What was their position? I mean, how did they get to, without regard to the exact number, how did they get to any number? I mean, you've got
They looked at a window of time, historical use, and said, this is really all you need. I mean, that's as simply as I could say it.
wow.
So that's around 92. We're up talking to Met. Met says no. Talking to San Diego. San Diego says yes. Let's see if we can work something out. Met and Coachella oppose, saying you can't do it. United States and the state of California get involved. We've entered into an agreement now with San Diego in 1998, October, well, I don't remember exact, April of 1998. And they, everybody kind of said, the United States especially said, how can you do this? You still have these flexible rights. IID. We pointed in our agreement with San Diego how we could do that without, I'm not going to get into that detail. And they said, we need to sit down. All of us need to sit down. And all of us meant, 30 plus people in a room, along with David Hayes and, and work out some kind of an agreement. So that resulted in what they called in 1999 key terms for quantification. And so the parties agreed that they would start working using those key terms to come up with an agreement that would take care of everyone and respect everyone's interests and take care of everyone's needs to the extent reasonably possible. And that resulted in, negotiations all over, Washington, D.C., we would meet in Denver, we'd meet in Sacramento, leading up to the quantification settlement agreement that, as you know, is one fairly short document, but it has 37 other agreements attached. No, not attached, but included. That, again, was still under the guise of working out a consensual arrangement under my old resolution 8-84. How best to protect Imperial Valley's water rights versus litigating.
In layman's terms, or maybe shorthand version is what I mean, what did the quantification settlement agreement do either to or for IID? What did they get and what did they lose?
Well, I have a list of 17 benefits, as I call them. I'm not going to repeat all of those
Well, the
today.
major one, maybe the major ones.
Yeah.
You can recall.
Our water right was recognized by all and agreed to be 3.85, less priorities 1 and 2, but that didn't change. The water right itself did not change. IMD is obtaining substantial funds to pay farmers to enter into conservation methodologies that will allow them to continue to farm the same crops with the same yield with less water. That all of the parties agreed that they would not challenge IID or the farmers' use of water throughout the term of the QSA.
Does that harken back to the California Constitution admonition against wasting water? I'm not sure the language is precise there, but that's what people were beating imperialism
Sure.
with, isn't it?
Sure. And there were a lot of other, and there were other initiatives going on about during this same time period. For example, we had the 4.4 plan of California that was essentially championed through the Colorado River Board, as you know. And it provided MWD a soft landing. In other words, United States would make more Colorado River water, surplus water available, even though Nevada and Arizona was using their full apportionments to MWD, with the caveat that quantification settlement agreement had to be entered into by the end of 2002. And we didn't have an agreement in 2002 because the ID board didn't think the protections that it was looking for, both from the state legislature, from the federal government primarily, were sufficient. So the Department of Interior, through the Bureau of Reclamation, sent a notice to ID saying, starting in 2003, we're going to reduce your water delivery by 300,000 acre feet. Because you're not using water reasonably, and you should have a water duty anyway. Things should be quantified, et cetera, et cetera. So we sued the United States immediately in district court again. And we said two things. Number one, we don't think Congress allows the Secretary of Interior to make reasonable use determinations of Colorado River water users such as IID, who have both a present perfected right and a state right under under the United States Supreme Court rulings that state law controls use of water. And secondly, even if the Secretary of the Interior does have that authority, they didn't exercise it properly, layman's terms. And the judge held that they didn't exercise it properly, issued an injunction, tell the United States he needed to continue delivering the water to to Imperial Valley and reserved a decision on that second issue about whether there's authority or not authority. That issue has never been decided.
Is it still waiting to be
No.
decided, or it just got?
We dismissed the case as a result of ultimately then in October 10th, 2003, quantification settlement agreement and all the other 37 agreements. Yeah.
Can we talk about the Salton Sea for a little bit?
Sure.
And Imperial Valley, or IID, well, both IID and Imperial Valley's influence on the Salton Sea, and interested in your thoughts about where the sea is headed, other than down a dark hole. I mean, something's got to change here. What's your what's the word I'm looking for? What's your history with the Salton Sea IID?
Well, I used to fish there a lot.
Okay. Well, that's right. When you were a young man,
Yeah.
that was a kind of a going concern.
Yeah, yeah. Fabulous. Yeah. Good times there. Well, as part of the deal with San Diego County Water Authority, as part of the QSA, we already knew that there was going to be less water flowing into the Salton Sea, and that the elevation of the Salton Sea would continue to decline. We entered into an agreement with the state of California as part of the QSA package and part of the San Diego deal and part of the state board approving the IID San Diego transfer, whereby IID, Coachella, and San Diego County Water Authority would contribute $133 million in 2003 dollars for Salton Sea mitigation as a result of the IID San Diego transfer. And the state of California would pay everything above that. Hard-fought negotiations. But we had, in many cases, the environmentalists on our side. So they wanted to make sure, the Salton Sea remained as healthy as possible.
But there was no cap on California's contribution?
There was a cap, $133 million.
No, on California.
Correct, there was not. In addition, the state of California agreed that there was some small amounts paid by IID, Coachella, and San Diego into a Salton Sea Restoration Fund. I'm going to say it was $30 million, but I don't remember the exact number. In the state of California, you pay that, we will be responsible for restoration of the Salton Sea. So we'll pay over $133 million for mitigation for the transfers, and we'll restore the Salton Sea. And you'll have no obligation to do that. And the state hasn't fulfilled that obligation.
And that I won't call it a promise, but that portion of the agreement was in what year?
2003.
2003?
Well, I think the legislation probably was either the end of 2002 or probably the first part of 2003.
In any case,
Jay.
it was about 15 years ago.
Yes. And they've been spending some money. They've had some bond funds that they've spent. They thought they were going to get some more bond funds as a result of the Tuesday's election, but they didn't.
Oh, did... So what's happened with Salton Sea in the last 15 years, with all this money on the table? Nothing?
Oh, there's been some, I would say, minimal to mediocre work done around with respect to some of the habitat around the perimeters of the Salton Sea. They are trying to figure out a way how to levelize the elevation. There's talk about bringing water from the Gulf of Baja. They've got three proposals that they're considering.
Well, is Imperial actively engaged? I don't want to dwell too much on the Salton Sea, but I'm interested with respect to Imperial because the Salton Sea occurs, at least a portion of it, occurs in their service area.
Right.
So, because they're a neighbor, do they have any unusual concerns about it, or are they just letting others deal with it?
No, they have huge concerns about it. As does Riverside County, Coachella. Because primarily because, well, a lot of issues, but the major one is dust issues, kind of like, Mono Lake issue. And so they're pushing, and they're involved in those discussions constantly.
So as a representing IID's or Imperial Valley's viewpoint, what's your future of the Salton Sea look like? You're going to be fishing there again?
It depends. It depends if one proposal has been to put dikes around to concentrate the saline water in the middle of the sea, but have a fairly significant shoreline out to those middle dikes. You could put fish in there. That could happen. I don't know. I don't know. I mean, the cost is significant. Doesn't make any difference what option they take. Will people ultimately make it happen? It's hard to say. And some of these programs with respect to bringing water from the Gulf, in my opinion, are promising. It's expensive, but they're promising. So the state at least has felt strongly enough that they went out for some RFPs, and they're now studying those three proposals.
So there is something going on.
There's some hope. Let's put it that way.
I had a problem interviewing you the first time we talked, and I have the same problem now, and that is that your knowledge, seriously, is so far beyond mine that I'm not even sure what to ask. I can only ask about what I know about.
Mm-hmm.
What don't I know about that I should be asking?
We don't have time, Jay. In all honesty, it's not because of my knowledge. It's just my experience, with all that I've been involved in.
Well, and this program, the Oral Histories, as you know, it's specific to the Colorado River, and so I try to think about Colorado River issues where IID is a significant player, and frankly, that's most of them.
Yes.
Talk to me a little bit about Indian water rights and IID. Are there collision points there, or is IID a benefactor of Indian water rights, or is it a non-player?
I would say IID is a non-player, other than there were some issues up around with the Torres Martinez Indian tribe around the Salton Sea. IID had a power line going through there. That got resolved. The All-American Canal Lining Act, which provided the 16,000 acre feet to the San Diego County Indian tribes in Escondido and Vista collectively. Not really too much more than that.
Okay. When the All-American Canal was built, it's long before your time, I know that,
Mm-hmm.
And the Coachella Canal, for that matter, when they were built with sand and dirt.
Mm-hmm.
They were earthen.
Correct.
And they leaked a lot.
Yes.
Nobody cared about that for a long, long time, or they couldn't afford to,
Couldn't afford it.
couldn't afford it. So,
And there was plenty of water then.
well,
Nevada didn't need it. It's all of its water. Arizona didn't need all of its water. There was plenty of water, so why do it?
well, that's great question.
We did have some litigation, as you recall, with some interests from Mexico, saying that when we lined the canal, that it was going to impact their groundwater,
Right.
okay, south of there.
They would lose water.
It would lose water, and we ultimately won that lawsuit.
Was Imperial involved in the discussions over the desalter, the Yuma desalter?
Yes.
To what degree?
That we thought that was a good idea,
Good thing to do.
good thing to do for what they were trying to accomplish, but that issue is still the issue itself is still in play today, the salinity issue with respect, minute 242 under the treaty.
Is it accurate, by the way, that any number of large Imperial Valley farmers are also farming in Mexico?
I wouldn't say large, but there are some farming in Mexico, Mexicali Valley primarily.
Does that create any conflicts, or because there are across the border issues. Salinity is one of them.
Right,
Shortage criteria is another.
right.
So if you've got, and I don't want to get into names because I don't want to get sued either, but to the extent that you have a farmer in Imperial who's farming in Mexicali and these issues come up, is that a problem, or is that just not your thing?
It hasn't been a problem to date.
Okay. Well, what haven't I asked you, John? What there are like 1,000 things, but what is important to you out there as Imperial is affected by the Colorado and its other partners being MWD and all that, and then the reverse of that. What are the other partners currently up to that IID's not crazy about or is looking at?
I think the primary one right now is the interim, they called drought contingency plan on the Colorado River itself. And we haven't seen the latest, or we haven't seen a term sheet, but I believe IID is going to be expected to make some water available to keep the elevation of Lake Mead higher so they don't reach a trigger point. Under the 2007 guidelines, I negotiated that with Arizona primarily and said, look, the Basin Project Act, 1968 Act says IID has priority over Arizona as a result of their Central Arizona Project legislation. And California shouldn't take any hit if there's a shortage. And we succeeded in that. 2007 guidelines are very clear about that. And Arizona could be taking as much as, 450, 500,000 acre feet hit, and more maybe, depending upon how bad the drought is. Well, now they've said, we said that we would talk about it in 2023, but we want to talk about it now.
Yeah, let's go on.
Yeah, and so I haven't been involved in those negotiations. I just know about them. We're back. IID is back at the table, saying, and California's back at the table saying, well, what good are priority rights? I mean, they're only good in times of shortage.
Right.
Just like IID's present perfected rights. If you look at a list of priorities in the lower basin in the Colorado River, IID's way down to the bottom. In other words, the top part would be Central Arizona Project taking the first hit. Okay? And you just, you can start calculating how much water we're talking about. It really doesn't impact IID's rights if we follow that priority system, which everybody has agreed to and the courts have blessed. They got to be down to, I don't know, pick a number, 3 million acre feet out of the 7.5 before IID would even be concerned. So they're asking that to change, at least for an interim period of time. But we know the handwriting's on the wall. If I had to do another resolution, I would do it in a way that makes sure our rights continue to be protected.
We haven't talked anything at all about the upper basin states, Mexico, Colorado, Utah, Wyoming. Are they a player with IID, or are they just too far removed from IID's issues? I don't know the answer to that.
Well, the answer is, though, they're very concerned about it.
The upper basin states.
Sure. The upper basin states are concerned. Sure, because what happens in the lower basin does impact their obligation to make sure that we get 7.5 million acre feet a year in the lower basin. And the more pressure that's brought to bear, it could impact them.
There's a point right there worth clearing up. I think many people, most people, almost everybody, believes that the Colorado River was divided 7.5 lower basin, 7.5 upper basin, and 1.5 for Mexico. I don't think that's correct, but you correct me if I'm wrong. I thought it was 7.5 lower basin, 1.5 for Mexico, and then whatever's left.
I haven't looked at that in quite some time. My recollection is it is 7.5, and 750 and 750 split between upper and lower. But.
Okay.
But again, I was involved in Minute 319. Those negotiations with Mexico were huge. Mexico essentially says, we're willing to make some conserved water available to users in the United States. We're willing to talk about taking some hits on shortages. And those negotiations now have continued on to Minute 323. And that's a significant benefit to the United States and can also help Mexico. So all of that's been going on too.
Wow. Well, one of the things that happens with these hard copies is that you and the family get a copy. So your kids and grandkids maybe someday when they're video game, as it were.
Yeah.
Whatever kids do these days, they're going to be watching it. And what would you like? What would you like for them to have gotten out of this discussion?
That I succeeded in what my original goal was when I came back to the Valley and started practicing water law, and that is protect the Imperial Valley's water rights. And as far as I'm concerned, they're still intact after all kinds of people, shooting arrows and bullets, et cetera.
And that's a big deal.
That's a big deal. To me, it is.
I'm sure it is.
Yeah, we've had people, of course, understandably, in the Valley says, well, you guys didn't get enough money, from San Diego, or you didn't get enough money from MWD, or, how all that is.
Well, sure. I mean, people at MWD that opposed the swap are saying Imperial took MWD to the cleaning.
Right. Yeah, so that's something we have to live with. But I hope my legacy is that I did what I thought was right for the Valley, and as I said, we still have the water right. Nobody's taken it away from us.
That's very true. Last question I have, and you don't have to jump on it if you don't want to. Are there any people out there that you've dealt with over the 50 years, 40 years, that that you found to be particularly intriguing, or you don't have to go into biographies of people?
No, of course not.
You know, folks that you've dealt with over the decades that you found to be, I don't know, adroit, interesting, unforgettable?
That's a very good question. I would say that as ID's chief negotiator for a long time on these water issues and the QSA and the San Diego deal, et cetera, that I've been lucky that the people that I have dealt with in California and Arizona, Nevada, all the other basin states, the United States, state of California, have been competent. I don't recall any occasion where I thought they had a secret agenda. I was able to get them to say, hey, this is what I need, or this is what I want in order to make this happen, and to be able then to work with them. I'd mentioned Carl Bronke earlier. I found him amenable, a great guy. I think personality-wise, really nice man, and very competent. And I suppose I felt stronger because I think he shared the vision that I had about how best to deal with these issues involving some needs for water.
Yeah, I will confirm that, having worked for him for a number of years, Carl's a very upfront guy.
Right.
And you hear it on TV all the time, his word is his bond. But in Carl's case, it was true.
It was true. Yeah, and there were others. There have been others, but it would, take us another day to go down the list.
Oh, gosh, I appreciate the fact that there are hundreds.
I would just say any of those other people that watch this, I'm talking about you too. Whoever you are.
Wherever you are.
Let me tell you a story.
Okay, go.
I was asked this in an interview that I had for Irrigation Leader magazine.
Okay.
About, well, what do you, John, try to accomplish when you're negotiating something in order to help protect the valley's water rights? And I said, well, let's back up. I said, first of all, if you have to negotiate, you negotiate, and you negotiate to win. And if you have to litigate, you litigate to win. But if you're negotiating an agreement especially, you need to put yourself in the other person's shoes to see exactly where they're coming from, what they need, et cetera. And never, ever underestimate the person you're negotiating with. So I tell this story about a big city lawyer comes to Imperial Valley to go dove hunting. And he shoots a dove and it falls down across the fence into a field. So he climbs up over the fence to pick up the dove, and just about that time, an elderly farmer comes up in his tractor and says, what are you doing? He says, well, I shot this dove and I'm here to retrieve it, take it home. He says, well, this is my property. You can't do that. He says, the big city attorney says, look, I'm one of the most successful lawyers in the world, and if you don't let me take that dove, I will sue you for everything that you own. And the farmer says, well, I guess you really don't know how we settle disputes like this in Imperial Valley. The big city attorney says, well, what do you mean? He says, we use the 3-kick rule. The attorney says, well, what's that? He says, well, since you're on my land, I get to kick you 3 times. you get to kick me back 3 times, and so on back and forth until one of us gives up. Big city attorney looks at the old codger and says, I think I can take him on this. So the farmer stands up, puts the toe of his boot into the midriff of the big city attorney. The attorney goes down on all fours. The next kick is to his thighs, and he struggles some more. And the third kick is in his rear, and the big city attorney falls flat face into a fresh cow pile. Attorney gets up kind of dazed and tries to clean himself up and said, okay, now it's my turn. And the farmer says, nah, I give up. You can have the dove.
That's very good.
So I remember Carl used to always say, don't fool with these guys in Imperial Valley. They know what they're doing.
You can have the dove. Well, John, I thank you very much. This will become part of the treasure trove, the archive of Colorado River Board, Colorado River Association of California, and thank you the second time for the time you took, and we appreciate you coming over.
My pleasure.